You're reviewing your granted claims against a competitor's product, or maybe a licensing partner just flagged a gap in the specification, and suddenly you're facing a situation you didn't expect after the patent was already allowed. You've discovered a defect. This explainer covers exactly how to fix an error in a granted patent through a reissue application, and what the deadlines and risks look like depending on the type of fix needed.
We are dealing with the procedural reality of correcting a patent that has already been issued by the USPTO. It's a high-stakes moment, especially when market share or serious investments are on the line.
The immediate reaction to this discovery is almost always the same. My patent already issued and I found a problem with it. Can this actually be fixed, or is it too late? Well, the short answer is yes, errors can be fixed, but the specific path forward depends entirely on the nature of the mistake.
Under 351 U.S.C. Section 251, a reissue application corrects a granted patent that's inoperative or invalid because of a defective specification or drawing, or because the patent owner claimed more or less than they were entitled to. The fundamental requirement here is that the error happened without deceptive intention. It has to be an honest mistake, not an attempt to mislead the USPTO. Having reviewed reissue oaths from inside the USPTO, we know examiners don't treat this as just a formality. They actively read the oath for internal consistency against the original prosecution history to ensure the stated error completely aligns with what actually occurred on the record.
Part 1. Broadening versus narrowing claims. The direction of your claim change dictates your entire strategy. Once you realize a correction is possible, the very next question is procedural. Is there a deadline I need to worry about, and have I already missed it? Time is absolutely the most unforgiving element of patent correction. That procedural timeline becomes highly critical when market share is on the line. If you want to broaden your claims to capture a competitor's product, what happens if you wait too long? Waiting too long has absolute consequences.
A broadening reissue, one that seeks claims broader in any way than the original patent, has an absolute 2-year filing deadline measured from the patent's original grant date. Under 35 U.S.C. Section 251D, that deadline cannot be extended for any reason. It cannot be extended for attorney error. It cannot be extended for ignorance of the deadline. Missing this window closes the door on broadening permanently. There's no petition, no showing of good cause, and no equitable exception that reopens it.
Now compare that strict timeline to a narrowing reissue. A narrowing reissue, which only narrows claims or otherwise does not broaden scope in any respect, carries no statutory filing deadline. It can be filed at any point during the patent's enforceability. You could file it shortly before litigation or licensing negotiations, where narrower, more defensible claims serve your interests far better than broader, vulnerable ones.
Part 2. The recapture doctrine explained.
Let's look at the primary obstacle examiners look for when reviewing a reissue application. This brings up a specific fear for many patent owners. Can I lose ground I already gave up during the original examination if I try to reissue? People rightfully worry about revisiting past compromises made with the examiner.
The recapture doctrine blocks a patent owner from using reissue to reclaim claim scope they gave up during the original examination to get the patent allowed in the first place. If an applicant narrowed a claim limitation to overcome a prior art rejection, they cannot later file a broadening reissue that removes or loosens that exact same limitation.
Examiners apply a strict 3-step test under MPP Section 1412.02 to catch attempts at recapture. First, they determine whether the reissue claim is broader than the patented claim in the relevant aspect. Second, they determine whether that broader aspect relates to surrendered subject matter. Third, they evaluate whether the reissue claim has been materially narrowed in another respect that avoids the surrender. From the examiner's side of the desk, this is exactly where broadening reissue applications most often stall. If you don't directly address the prosecution history and explain why the reclaimed scope isn't actually the surrendered subject matter, you will receive a rejection.
If you want the full step-by-step breakdown of what goes into the reissue oath and how claim amendments need to be marked up for examination, the full article is linked in the first comment below.
Part 3. Intervening rights and competitors. We need to pivot to the market implications of changing your claim scope after a patent has already been public. Changing the boundaries of a patent creates real business variables. Will a competitor who's already using something close to my broadened claims get to keep doing it?
Broadening a patent's claims through reissue creates intervening rights. This means competitors who already made, used, or substantially prepared to make or use something covered only by the newly broadened claims before the reissue grants get legal protection to keep doing so. Anyone operating in that newly claimed space prior to the grant date receives absolute intervening rights for their previous activity. Furthermore, a court can grant equitable intervening rights, allowing them to continue their manufacture or use based on investments they made in reliance on the original narrower claims. Broadening claims to capture a competitor's product only works if that competitor's relevant activity started after the reissue grants.
Part 4. Alternatives to reissue applications.
Reissue is a powerful tool, but it's not the only tool. We have to evaluate if a full reissue is actually the right mechanism for the specific defect you discovered. Filing a reissue when a simpler mechanism would do adds unnecessary cost and time. So you have to ask, do I need a full reissue application, or is there a faster, cheaper fix available for the USPTO records?
When we break down the distinct use cases, clear lanes emerge. A certificate of correction handles clerical or typographical errors like a misspelled inventor name or an incorrect assignee without changing claim scope. It's faster and it's less expensive. An ex parte reexamination addresses questions of patentability raised specifically by third-party prior art rather than a self-identified drafting error. A reissue application is specifically required whenever the correction involves substantive changes to the claims or the specification because of how the patent was originally prosecuted.
Which brings us back to the most critical procedural warning. If you are broadening claims, the 2-year clock starts the day your patent grants. Nothing stops it.
The one thing to take away, if you're broadening claims, the 2-year clock starts the day your patent grants, and nothing stops it, so that decision simply can't wait. For the complete comparison between reissue, a certificate of correction, and ex parte reexamination, and which one actually fits your situation, the full article is in the first comment. If you want more guidance like this on patent prosecution and USPTO procedure without having to search for it every time, subscribe. So look at your most valuable allowed patents right now. If you found a fatal flaw in Claim 1 today, would you still have time to fix it, or is your 2-year window already closed?